Hello, my name is Chris and welcome to our When Land Meets the Sea podcast, a coastal mini-series by David Jones Bold. On this podcast, Richard and Lizzie take a road trip around the coast of England and Wales and visit some of the most significant cases and legal issues relevant to the coast. UK coastal towns are some of the best places in the world to be, but they also face major challenges, faring disproportionately worse than inland towns and cities for health, education, socioeconomics, crime, and more. Through this group, we are working to change that. For example, we recently worked with the government to get coastal communities added to the list of mayor competencies under the English Devolution and Community Empowerment Act 2026. We've also developed a framework for coastal placemaking and stewardship, which you can download for free at www.djblaw.co.uk/blue-horizons. Enjoy the podcast.
Hello, Richard.
Hello, Lizzie.
We are going to continue our tour of the coastline today. And we're going to stay, close to home for me. We're going round the West Country, which, as I'm sure everyone knows, because you tell everybody, is where I'm from.
Yes, you're a Somerset girl.
I am indeed. And we're going to be focusing on easements and covenants, cases in relation to those in particular. So do you want to start with arguably the most famous one from Weston-super-Mare?
Yes, what better place to start our tour of the West Country than Weston-super-Mare. The Re Ellenborough Park, in the characteristics of an easement, 1955 Court of Appeal decision. And basically, do you know Ellenborough Park? Do you actually know it, Lizzie?
Yes, I do. I don't know Weston all that well, though. It's not really my beach of choice.
Country, but I used to live there. I used to live in the West Country for most of my life. But I have never been to Ellenborough Park, and I've only been to Weston twice. But I know of it through the easements case. It's not coastal, it's just inland, but I didn't realise this until I was looking at these podcasts. It used to be coastal. It was, it's about 300 yards from the sea now, from the Bristol Channel. But it used to be sand dunes, which back in the 1850s were covered over with various materials, and Ellenborough Park was built. And homes primarily for people retiring from Bristol in the 1850s and the likes. And they had the use of the park itself, which is about 7.5 acres, and it's split in two by a minor road. And the western side, which used to be the sand dune side of things, is a site of special scientific interest because through the rubble and everything, various sand-based plants will pop up to this day, such as the sand cat's tail. You're aware of them?
Okay, no.
The sea stork's bill, and of course the smooth rupturewort.
I'm sure these are things you've picked up in the last 24 hours when preparing for this, and shouldn't be expected to actually know what these things are.
The smooth rupturewort, so called because it's supposed to have been a cure for hernias. How could I have picked that up in the last 24 hours? They basically, I say the inhabitants of the houses around Ellenborough Park had the right to use this park themselves. And the question is it a property right? Is it an easement, basically, which is a type of property right, or is it just a license? Because the background is that if it was an easement, then they'd be entitled to compensation because Ellenborough Park was requisitioned during the Second World War because of its strategic significance. You know that old expression, whoever controls Weston-super-Mare controls Britain. You know that one from the West Country, don't you, Lizzie?
Yeah.
Yeah. And there's something called the Compensation Defence Act. You're entitled, if you had your land requisitioned, you'd be entitled to compensation. So did they have property rights? And the Court of Appeal and Lord Evershed basically said to have an easement, there's got to be a potential easement. There's got to be a dominant and servient tenement. You own a piece of land yourself. You can't have what's called an easement in gross. If you don't own land, you can't have an easement, but there was a dominant tenement. The right you're claiming must benefit the dominant tenement, accommodate it. It's not just personal. It makes your land a better place than it did. There's got to be diversity of ownership and or occupation. Different people own or occupy the two pieces of land, including obviously landlords can claim against tenants' easements and vice versa. But we had that as diversity, ownership and occupation. And the right you're claiming must be capable of forming the subject matter of a grant. And they decided it would be capable of being granted in a deed. It's a sufficiently certain and lights. And the right to use garden for pleasure purposes could be an easement, so they got their compensation. And that's the background to Ellenborough Park. Not many people realise the background.
Thank you. Well, next, are we moving on to Wilkinson and Kerdene?
Yes, we'll go right down the coast. We'll go right along the Bristol Channel through North Devon and into North Cornwall between Padstow and Newquay, St Mirren and Holiday Village. It's just off from the coast again. It's not about easements, it's about covenants, and it illustrates one of the great problem areas in English and Welsh property law. And that in freehold land, positive covenants that require you to do something are not property rights. The effect of a disastrous case in 1985, a court of appeal case called Austerbury and Oldham Corporation, which they ought to do something about reversing in Parliament one day, but they won't. That they're not property rights. If they're not property rights, they don't mind third-party purchasers. And it was a holiday village. It had been a former Fleet Air Arm airfield in the Second World War, which became surplus after the war and the likes. And it was sold off to be this holiday village. And people be, sort of long-term owners of, bungalows. I think at the time of the case, there's 147 bungalows. I think it's got a bit bigger since, and there's some chalets in this particular piece of land. And they had to pay for things like those roads, obviously, and sort of footpaths maintained and painting and this kind of stuff. They had one big sort of, if you like, service charge. Things like pleasure facilities. There was a pub there. There was a boating pool and an amusement arcade. It sounds perfect. When shall we go? But they had all these kind of things. And they're positive, they're paying for the maintenance of these things is obviously a positive obligation. So on the face of it, you don't have to pay. Mr. Wilkinson was objecting to the fact that Kerdene had bought this premises and it had become run down and they wanted to spend lots of money doing it up and the likes. And Wilkinson seemed to have objected to this on the basis that, I don't use half the facilities. I don't go to the amusement arcade and so on. And it's something called the doctrine of mutual benefit and burden. It's based on a case called Halsall and Bristol, which is also a coastal case, actually. Not from the West Country, but we'll go up to Merseyside quickly to Liverpool. It's a place called Cressington Park, and it's on the Mersey estuary. And they had to pay for maintenance. It's freehold, and they had to pay for maintenance of private roads and sewers and drains, and also a seawall. They had to pay for the maintenance of the seawall. And although they're positive obligations, the court decided that if you want the benefits of using the roads and the sewers, then you have to pay for the seawall, and you have to pay for the burden. And that's what they decided to the Court of Appeal in 2013 in Wilkinson and Kerdene. If you want the benefit, you've got to suffer the burden. It's not ideal. They also said that, because it's one big payment, it doesn't matter if you're not using some of the facilities and like you still have to pay. So that was Wilkinson and Kerdene. Shall we move on along the coast?
Yes. Are we staying in Cornwall for the next one? Jelbert and Davis?
Cornwall. We're just going around Land's End, just to the east of Penzance, Goldville. And again, it's a holiday camp. Well, it's a caravan site to be precise, just inland. And shall I tell you about that?
Yes, please.
Yeah. Jelbert, or the Jelberts, were a well-known Penzance family. They basically, it was farmland, but they got permission to convert it into a caravan site. And they had access across Davis's land. They had an easement of access, an express easement for all purposes, which is common thing to see. An easement can be used at all times and all purposes. And they got permission. The neighbouring land was also farmland, and they got permission to convert it into a caravan site. In the summer months and holiday season, there wouldn't be half a dozen tractors as in the past the day going up and down this trackway. There'd be 200 cars and caravans, and Davis objects to this, and the court decided in 1968 that objections are correct. It's all about intensification of use. You can't unreasonably intensify the use of the land, and converting, even if you've got an all-purposes easement, converting from half a dozen tractors a day to 200 cars and caravans is unreasonable intensification of use. There's been lots of cases since. There was a case from Kerdene's homes in Robinson, which was from Bognor Regis, which said the question is whether there's a radical change in the character of the land rather than just an intensification of use. And is there a substantial increase or alteration in the burden to the servient owner? But either way, half a dozen tractors going up and down being converted into 200 cars and caravans is unreasonable. Shall we move on?
Yes, so we're going back up the coast to Devon now.
We're going up to Devon.
Churston Golf Club.
The Churston Golf Club and Haddock. Now, obviously, Lizzie, I chose, we're talking about the coast, and I chose this one because Haddock live in the sea. It's a farmer Haddock. He's got the wrong idea for his job. Nominative determinism. He shouldn't be a farmer. It's about easements again, and it was an important case. It's quite a recent case from 2019, which reversed the first instance decision. Churston is right on the coast. It's between Brixham and Paynton, and it's famous for the Searle bunting. It's the last major stronghold of the Searle bunting in Britain. Did you know that?
I did not know. Every day's an education.
Would you like to know what a Searle bunting is, or have you already looked online?
No, you can tell us.
It's a little bunting, a little bird, which is a bit like a canary. But it isn't a canary. It's a bunting. But anyway, they hang out in the Churston Golf Club. But it's right on the coast. I've actually been up this road and had a look at the Churston Golf Club for all time's sake. Back in the early 1970s, the council had purchased part of this land. It was the Churston Barony Settlement, and the Torbay County Borough Council, as it was at the time, had purchased a part of this land. And they'd agreed when they purchased it that they would maintain and forever hereafter keep in good order a stock-proof fence between their land and the retained land. And what then happened is they granted a 999-year lease to the Churston Golf Club, who built the golf course and all that, clubhouse and what have you. Quite a posh place, apparently. And the neighbouring piece of land, which was Churston Court Farm, was leased out to Farmer Haddock. And some years later, he was complaining that the Churston Golf Club, said basically that you must maintain, and it also said you and anybody deriving title under you must maintain forever hereafter the stock-proof fencing. And he was complaining that the fencing hadn't been maintained by the golf club, and cattle were getting out of his land and onto the golf club and the likes. Again, it's a similar thing to which we've mentioned in the Wilkinson and Kerdene case. Maintenance is a positive obligation, it's a positive covenant, and on the face of it, it won't bind third-party purchasers. It will bind the original owner, and Torbay Borough Council settled the case, but he wanted to have a go at Churston Golf Club as well. There have been a couple of cases back in the 60s and 70s, Jones and Price and Crow and Wood, which were all about fencing covenants. Normally, you can't have an easement of positive expenditure. If you're required to spend money on the land, it can't be an easement. But the exception, if they are easements or not, with these fencing covenants where there were customary obligations to fence off against animal trespass and the likes in the mid Wales and the North Yorkshire moors. And at first instance, the court decided that this positive obligation to maintain the fencing was an easement, which would have changed the whole of property law. It went to the Court of Appeal and said it isn't an easement, it's called a positive covenant to maintain the fences, and that's what it is. And it doesn't bind third parties unless you've got something else like a series of deeds of covenants and the likes between various purchasers and sellers. It would have been massive if it had gone the other way. But you're getting an everyday conveyancing, you have an obligation to put up and maintain the boundary fence. Unless you've got a chain of covenants, it doesn't bind third parties. But shall we move on, not far away?
Yes, please. Staying in Devon for the final case, Stenner and Teignbridge District Council.
Yeah, in Teignbridge, not Cambridge, but Teignbridge District Council, just up the coast, from the Churston, just a bit further east and north. Teignmouth in South Devon. And I've been to this place as well, Lizzie. I parked in the very place, the Lower Point car park in Teignmouth, just on the estuary, at the end of the estuary. And Mr. Stenner, since the early 1980s, had been leaving pleasure boats on this particular piece of land in the out of season, between October and the middle of May or something. He was running these half a dozen pleasure boats up and down the estuary and into the sea, and stored them there and sort of maintained them. And whilst they were being stored there, they couldn't, people could walk between the pleasure boats, but obviously you couldn't park your car and the likes there. And to cut a long story short, he also had some beach huts in the area, which would be his dominant tenement. He claimed an easement by prescription for long use. These pleasure boats have got this neighbouring piece of land and the likes. And it's something called the ouster principle. There's been lots of cases on car parking, and the whole idea of an easement is that you can't exclude the servient owner from the land. So there's cases galore on things like car parking. It's something I've become famous for. I was the one who spread that one, Lizzie. You can't have an easement exclusive possession, and therefore if you're entitled to park in exactly the same space all the time, it can't be an easement. If you're parking on the first come first serve basis, or you can be moved around on management grounds, it can be. There's another Torquay case. Torquay is a wonderful place for property litigation. Newman and Jones that said if you're parking on a first come first serve basis, it can be an easement. But to cut a long story short, the court decided that Mr. Stenner was exclusive possession of the land. He was ousting the council from use of the land, and it couldn't be an easement. It was based on a case called Batchelor and Marlow, a court of appeal case in 2001. But next month, we're in June at the moment, it's what day is it today, the 25th? But on July the 22nd, it's going to the Supreme Court. This was an upper tribunal case. If I said it was a court case before, it's an upper tribunal case. It didn't go to the Court of Appeal because its significance, and Batchelor and Marlow was a Court of Appeal case. July the 22nd, the Supreme Court will hear it. So sometime, I'm presuming later this year, we'll have a final decision as to not just leaving boats on in a triangular part of the car park, but on car parking generally, and things like exclusive use of a roof terrace, exclusive use of moorings. There's been a case in the Norfolk Broads on that, PNS Platt and Crouch. And I'm looking forward to it, and no doubt when we know, we'll have a podcast on it.
Indeed we will.
And that's my tour of the West Country.
Thank you very much, Richard.